Thank you. Thank you so much for having me. And I want to thank very much Susie Frankel for inviting me to speak today, and Jonathan Boston for chairing this session. It's always wonderful to be on the same program with someone named Jonathan. And my middle initial is also B, so I'm also a Jonathan B. And I lived for many years in Boston. My mother's name was Susie, so I feel right at home. I'm sorry that I could not be with you today in Wellington. I was very eager to make the trip, but it's this week is our exam week at my university, and so I was obliged to stay here and conduct my exam for my students. I did have the opportunity to visit Wellington about a year ago for the IPCC, the Intergovernmental Panel on Climate Change, which had one of our authors' meetings in Wellington last year, and I very much look forward to coming again. I know you've already had a full day of your conference on regulation and regulatory reform, and the large project that you have underway with the New Zealand Law Foundation, which I think is very impressive. What I will try to talk about today is a project that I conducted on comparing regulation in the United States and Europe. And that project, I think, has two major suggestions or outputs for your conference. One is the value of careful comparative research to overcome the stereotypes or poorly drawn generalizations that are often used to characterize different regulatory systems. In short, we see a much more complicated story of comparing regulatory systems than is often presented. And the second is to take account of the spread or diffusion of regulatory policy instruments, such as emissions trading or tradable permit markets, like Jonathan Boston and I were just discussing New Zealand's attempts at an emissions trading system for greenhouse gases, and the United States also that has been a halting effort. And more particularly today, I'm going to speak about the global diffusion of regulatory oversight systems, the use of regulatory impact assessment. Again, focusing on the United States and Europe, because that's the research that we have just been conducting, but I'm very eager to extend this research more globally. And so I would very much welcome your reactions and your comments from the perspective of what's going on in New Zealand or New Zealand and Australia or anywhere around the world. So I might just say next slide, please, each time I ask for the next one. So next slide, please. This is the slide that says comparing risk regulation. When we began this project that produced the book, The Reality of Precaution, here's the book. I'll show it again a little later. There was a hot debate between American and European governments and experts over the precautionary principle, with many in Europe advocating the precautionary principle and many in the United States, both in our administrations of President Bill Clinton and President George W. Bush, criticizing and resisting the precautionary principle. There was a lot of confusion about what the precautionary principle actually meant, but a claim that one often heard was that Europe has become more precautionary than the United States. And so we wanted to conduct a research project that would go beyond the abstract and acrimonious debate and look in more detail with a more fine-grained analysis at the actual policies that had been adopted in the United States and Europe for a wide range of risks, and test to what extent has Europe actually adopted precaution or precautionary policies, and to what extent has the United States done so. And there are a variety of different claims that were being made. One is that Europe is always more precautionary than the United States, It's a matter of different cultures of risk. A second claim was that it's only recently that Europe has become more precautionary, whereas earlier the United States was more precautionary, say in the 1970s and 80s. But that since about 1990, Europe has become more precautionary than the United States. And that's a claim that's most closely associated with, in academic work, with the work of David Vogel at the University of California at Berkeley. And he has a book that was just published in 2012 called The Politics of Precaution that makes this claim. And we thought there was a third possibility, which is that there have been precautionary policies in both the United States and Europe, and that it's much more a question of selective application of precaution to particular risks rather than an across-the-board adoption of precaution or the precautionary principle in all of European regulation or all of American regulation. And that relates to a broader question, not only about precaution, but about regulation more generally. Are there distinctive national styles of regulation? And in 1986, David Vogel had published a book called National Styles of Regulation, arguing that that the United States has a style of regulation, that the UK has a style of regulation, and so forth. And we thought that the reality might be more complicated than that. So we tried to investigate what is the real pattern of precaution, what has led to it, and what are the implications, both for, as I said a moment ago, for the methodology of comparing regulation across countries and for the improvement of regulatory policy. Next slide, please. So one claim that we all hear very commonly is that there are divergent cultures of risk. So, for example, that Europe is risk averse and that Europeans have a culture of risk aversion, or that they're skeptical of new technology, more willing to seek collective approaches, or more favorable towards government. Whereas the United States is cast as more risk-taking, more optimistic about technology, and more individualistic and skeptical of government. But interestingly, both David Vogel and my work, our own work, find that these are inaccurate stereotypes that do not reflect the actual reality of policymaking. These are really caricatures that have been drawn for a long time in literature, often as comical parodies of the reality. And so even in The Barber of Seville by de Beaumarchais, he was making fun of European precaution. James Fenimore Cooper's first book, is a famous American writer, was called Precaution. But my favorite example is Oscar Wilde's short story, The Canterville Ghost, published in 1887, in which an English country home is haunted by ghosts, a kind of uncertain emergent risk, and the British family living there is terrorized by the ghosts, but they invite an American family to move in and rent the house, and the American family, of course, arrives with every technological invention necessary to get rid of the ghost. They even make friends with the ghost. But Oscar Wilde was, of course, using this to lampoon, to parody the reality. And these broad cultural stereotypes are inconsistent with claims that American and European regulation have changed or even reversed or switched positions over time, which is David Vogel's current claim. And they're inconsistent with the wide variation we see within European and American policies, and in particular with examples like regulation of tobacco in the United States, which would be seem to be risk-averse and favorable towards government regulation of individual choice, or to a variety of other particular examples. I think a more modern view is that the culture of risk-taking co-evolves with the choice of risks to worry about and the choice of risk policies. That's a view closely associated with Sheila Jasanoff's work. Sheila Jasanoff takes the view that these cultures of risk are so deeply embedded and co-evolved with policymaking that we can't compare policymaking Our view is that we can compare, and at least compare the degree of precaution, the degree of stringency, the types of policy instruments that are used, even if making normative judgments about the optimality of those policies is more difficult. Next slide, please. And so a second claim that I mentioned is that there are distinct national regulatory styles or legal origins. And you may be familiar with that in the basic literature on comparative law, in which the claim is often made that different countries belong to different legal families. Also, as I mentioned, David Vogel's work on national styles of regulation from 1986, which interestingly in his new work, he has retreated from that point because he's now arguing that Europe has reversed positions to adopt what he used to think was the American regulatory style. And you, excuse me, and you may be familiar with the work by a group of economists, Laporta et al., on the so-called legal origins theory, which was then incorporated into the World Bank's Doing Business reports in an effort to rank countries by their hospitability to business. And those, the World Bank's Doing Business reports and the Laporta et al. Academic work makes the claim that countries' current modern approaches to regulation, especially regulation of business and labor relations, are deeply tied to their ancient legal origins in these legal families, in English law or German law, French law, and so on. But even the Laporta et al., who make this very strong claim about modern regulation being rooted in ancient legal systems, legal origins, include one sentence in their summary article in 2008 in which they say that our theory may not apply to new spheres of social control. And by new spheres of social control, I think that encompasses all the kinds of risk regulation of health, safety, environment, and national security risks, homeland security, that we are interested in our research. So we take the view that the reality is not of distinct and fixed national styles of regulation, but a much more fluid and variable world in which we live in webs of diffusion and hybridization, the mixture and reinvention of regulatory systems through borrowing of approaches from other countries. Next slide, please. So that brings me to the claims of reversal. And if you'll click one more time, we have a series of examples that are often cited to illustrate greater European precaution, especially in the last 20 years. Genetically modified foods, hormones in beef, climate change, toxic chemicals, and others. All examples of European regulatory precaution compared to the United States. So if you click again, that's a view that is espoused by a variety of voices from European Union officials. So click again, please. And I hope you see the quote from Pascal Lamy.
Yeah. Yes, we do.
When he was European Union Trade Commissioner, before he ran the WTO, Pascal Lamy made this comment, that in the United States they believe that if no risks have been proven about a product, it should be allowed. In the EU, we believe something should not be authorized if there's a chance of risk. He could not really have meant that because that would require banning everything in the EU. But the contrast is evident in his comment that the United States is waiting for evidence of risk, whereas the European Union is acting in anticipation of emerging risk, which is the essence of precautionary policy. So if you click again, a number of newspaper headlines and magazine headlines indicating this generally adopted view that, or frequently repeated view, that Americans are risk-taking or at least open to risks, and Europeans are more risk-averse, more precautionary. And click again, please. And there's David Vogel's work and others arguing that there has been a shift or reversal from greater American precaution in the 1970s and 80s to greater European precaution in the 1990s. Next slide, please. Do you have Theophanous Christophorou or David Vogel?
David Vogel.
Okay, good. So here's a quote from David Vogel's most recent book to illustrate the kind of now well-developed academic research on this kind of point. And you see David Vogel arguing that previously, before 1990, Americans had been quicker to respond to new risks, had been more precautionary, whereas since 1990, Europe has moved ahead of the United States to become more stringent and more precautionary than the United States across health, safety, and environmental risks. And here he lists a number of those examples: climate change, genetically modified foods, antibiotics in animal feed, hazardous waste, chemicals in cosmetics. And David Vogel attributes this asserted reversal to three main factors. One is changing public opinion. Essentially, he argues that in the United States, Americans became satisfied with the level of protection that they had achieved and didn't want to ask for more. And whereas in Europe, Europeans wanted a higher level of protection. He does not go into a lot of detail about why that is, why those changes occurred, but he cites that change in public opinion. Second, he argues there's been a change in leadership priorities, and in particular here he's focusing on the domestic politics within the United States and the Republican Party in the United States becoming less willing to adopt or support new regulations than it had been in the 1970s and 80s. And the third factor he cites is changing criteria for policymaking, that the United States adopted benefit cost analysis or regulatory impact assessment, and he says that Europe did not. And let me just mention there that actually the history of the change in criteria for policymaking, I think, is more the opposite of Vogel's claim, because the United States adopted cost-benefit analysis for regulatory impact assessment really starting in the late 1970s under President Jimmy Carter, and then more forcefully under President Ronald Reagan in 1981. So at least 10 years before the shift that Vogel suggests. And then the European Union, at least at the European Commission and now more recently in the European Parliament and other institutions, has adopted impact assessment using a version of cost-benefit analysis starting with the Better Regulation Initiative in 2001 at least. And so actually one might see the opposite trend if one thought that regulatory impact assessment and cost-benefit analysis was a check or a brake on precautionary regulation. Then one might have seen the United States shifting back in 1980 and Europe shifting away in around 2001. Next slide, please. Do you now have Theophanous Christophorou? And I'm just asking because I had sent Susie, regrettably, I had sent her more than one set of slides.
No, I'm afraid he's fallen out. We now have the rise.
That's good. That's fine.
The rise of the precautionary principle.
Okay, that's good. So there is. I want to say here that there is evidence for David Vogel's hypothesis, the rise of precaution, particularly in Europe. And some of that evidence is in the official adoption of the precautionary principle in judicial and legislative and treaty law on both sides of the Atlantic. So in the 1970s, both European and American regulatory actors were adopting precaution or the precautionary principle. The German Vorsorgeprinzip as early as 1970, similar principles in Sweden and Switzerland, and also in the United States. The U.S. courts in 1976, a major court decision characterized the United States Clean Air Act as a precautionary statute. And in 1978, by the way, the United States Supreme Court characterized our Endangered Species Act as an exercise of institutionalized caution. So the term precautionary or caution was being widely applied in the 1970s to refer to American regulation. But in 1980, the United States Supreme Court, in a case commonly referred to as the benzene decision, essentially held that regulatory agencies had to show quantitative risk assessment before they could regulate at low levels of exposure. And that although that decision really only applied to one agency, our Occupational Safety and Health Agency, it was handwriting on the wall for all the federal regulatory agencies that they should develop quantitative risk assessment. And in the view of many, that put a check on anticipatory precautionary regulation before there was strong evidence of risk. Meanwhile, in international law and in European law, the precautionary principle continued to be adopted. So in 1992, the Rio Declaration, which I should say the United States also signed, in paragraph 15, endorsed the precautionary principle. In 1992, also the Maastricht Treaty adopted in European Union law the precautionary principle, and that remains in the current European treaty, the Treaty on the Functioning of the European Union, adopted in Lisbon in 2009. It's now in Article 191. But it was not clear what the precautionary principle meant in the European treaty law. So in the year 2000, in February 2000, the European Commission issued a communication on the precautionary principle which attempted to define it, and interestingly defined the precautionary principle as including risk assessment and cost-benefit analysis. So I think in many ways reclaiming precaution as part of decision analysis for regulation. And as you know, versions of the precautionary principle have been widely adopted in Canada, in Australia, and elsewhere. Next slide, please. So here, I hope, is the cover of our book, yes, and our effort to test these claims. We held 4 conferences, which we called Transatlantic Dialogues on Precaution, 2 in the United States and 2 in Europe. We engaged many, many experts in those conferences, and then we compiled a book including 27 authors, about 12 case study chapters on specific risks, and I'll tell you about those in just a moment. And then we also did something that may not have been done very often before, which was that in addition to case studies of regulation, we also attempted to collect the universe of all risks subject to regulation in the United States and Europe from 1970 to 2005, and to take from that large universe a sample of representative risks, and then to test the degree or trend in relative precaution on that large N data set. We also had a set of cross-cutting chapters on institutions and perceptions to try to explain relative precaution, and a concluding synthesis chapter. Next slide, please. So this gives you a quick summary of the table of contents of the book, The Reality of Precaution, and particularly the list of case studies, including several of the cases that David Vogel and others frequently cite as examples of greater European precaution. So genetically modified foods, hormones in beef, climate change, but also a number of other case studies that we thought were also interesting in illustrating the variety of approaches to precaution. So tobacco, nuclear power, biodiversity conservation, both on land and in the marine environment, toxic chemicals, of course, medical errors, and terrorism or homeland security. And we have a number of other chapters on information disclosure systems, risk analysis methods, then the quantitative large data set study that I mentioned, and then a series of explanations and conclusions. So next slide, please. Now, we fully recognize that the definition of the precautionary principle is elusive, and there are many different definitions and no single or coherent statement. But our project was not meant to dismiss the precautionary principle as undefined. Rather, we were looking for a metric or a scale on which we could measure relative precaution. So next slide, please. So we looked at narrative definitions of precaution, including the version that's in the Rio Declaration from 1992, that lack of full scientific certainty does not justify postponing action to prevent a risk. So that's a kind of authorizing or permissive version that says governments may regulate risks even when there is uncertainty. There's also a more aggressive version, here version 2, that uncertainty justifies action, and then an even more aggressive version, version 3, that is the burden shifting approach to precaution, that the proponent of an activity bears the burden of proving that the activity poses no risk or acceptable risk or is safe before the activity can go forward. And depending on the standard of proof there, no risk or acceptable risk or is safe, that version 3 may be very, very stringent. So if version 3 said the proponent bears the burden of proving that the activity poses no risk, then no activity could pass that test. That would be ultra stringent. Next slide, please. So here is a graphical representation of our attempt to define precaution as a sliding scale or a continuous variable. Because our intent here was not to classify regulations as either precautionary or not, in a binary sense. Rather, our attempt was to define relative degrees of precaution so that we could compare regulations across the United States and Europe, or really across any two countries or multiple countries, according to their relative degree of precaution. This would also enable us to compare over time changes in regulatory policies as becoming more or less precautionary. So we tried to define this metric of degree of precaution in two variables. One is stringency, that is how tightly the regulation attempted to prevent the risk. And the other is timing or earliness, that is how early in anticipation of an uncertain emerging risk the regulation was adopted. So earliness is a proxy for the lack of information about the risk, because the regulator who adopts an earlier regulation is acting under greater uncertainty. And that we thought was a key factor in precaution and in many of the narrative definitions of precaution. I think, by the way, that David Vogel in his work uses the same two factors. He often talks about stringency and anticipation of emerging risks. We were explicit about this in our book. Next slide, please. So to recap from the claims that I mentioned at the beginning, we are looking at a series of different hypotheses for the evolution of regulatory systems in the United States and Europe. One hypothesis is convergence, that international trade, globalization will compel national governments to adopt similar regulations, to harmonize in order to avoid trade distortions or in order to avoid competitiveness losses. A second hypothesis is divergence, that there are different cultures of risk, and so different countries will adopt different sets of regulations to reflect those different cultures. A third hypothesis is the reversal claim that David Vogel and others make, or that was implicit in or explicit in those newspaper headlines and even in Pascal Lamy's comment, that Europe had become more precautionary than the United States since about 1990. And our fourth hypothesis is what we called hybridization, or selective application of precaution to different risks, and furthermore, borrowing of regulatory ideas across countries and across regulatory systems, rather than distinct and separate and separately moving regulatory systems. Next slide, please. So I'm about to show you our comparisons, but before I do that, I want to be careful to say that one has to be cautious about comparing precaution or about comparing regulatory systems. Broad claims are easily overstated. I mentioned that earlier about the cultural claims that are often just stereotypes. The comparisons can vary significantly by the component of the regulatory system, not only regulatory standard setting, which is what we are mainly looking at, risk management, but also risk assessment, enforcement, implementation, the role of the courts, the role of executive agencies and legislatures, the role of private sector or civil society. All of these may vary. It's also often seen that when people are divided into groups, even at random, they start announcing contrasts between the groups. And there's a literature in psychology and sociology about exaggerated intergroup contrasts. A lot of that work was focused on race relations, or how people sorted into different groups can become prejudiced against other groups even when there are no underlying differences between the groups. And I think there's a version of that going on here as well, that people in different countries or different legal systems may exaggerate the contrasts between them. Those are, but the underlying a lot of the academic literature is sampling bias or sample selection bias. Claims made, generalizations drawn from just a few examples. And so our effort in our research project was to avoid that sample selection bias problem by looking at a wider array of case studies and by looking at the aggregate data, the large N data set. And it's particularly that large N data set which deals with the sampling selection bias problem. So let me now talk about the case studies and the large data set, and then after that I will speak about the diffusion of regulatory oversight. The case studies that we looked at are very informative about each case taken on its own. They're narrow in that sense, but they're deep in our inquiry into each case study. And those case studies that were very helpful in the 4 conferences that we held and in the research project overall, which lasted about 10 years. Those case studies were very helpful in fostering pragmatic dialogue. So when we brought European officials and American government officials together, the case studies were very enlightening for them in the variety of approaches to precaution and regulation that were being taken in the United States and Europe. And they saw from those case studies more variety than they had expected from the common claims that were being made. On the other hand, these case studies are themselves subject to sample selection bias. And so even our set of 12 case studies compared to Vogel's set of 4 or 6, our set as well is subject to sample selection bias, our cases versus your cases. And they are not an adequate basis for large-scale extrapolation or for making broad, generalized claims. Next slide, please. So, pardon me?
We're on to new drug approval. Is that all right?
Okay, very good. So let me just mention quickly, I'm not going to go into the details of each of these cases. We can talk about them further in the Q&A. Let me just mention several cases that are consistent with the reversal claim. That is, they do illustrate greater American precaution before 1990 and greater European precaution after, or sometimes the date is slightly different. But one is new drug approval, where both David Vogel and we agree that the United States Food and Drug Administration was highly precautionary in the 1960s and 70s, and then in the 1980s became less precautionary because it had received a lot of criticism about the drug lag, about slow approval of new drugs in the United States, even though that slow approval was based on concern about the side effects of those drugs. In the 1980s and 90s, the United States FDA sped up drug approval. Now there's perhaps approximate convergence with the European Union. Next slide, please. CFCs and GHGs, or stratospheric ozone depletion and climate change, also illustrate the reversal hypothesis. In the 1970s, the United States acted far more precautionarily than did Europe on stratospheric ozone depletion. The first regulatory policies adopted in the U.S. states in the late 1970s and the U.S. Clean Air Act and EPA regulation in 1977-78 were only 4 years after the publication of the theoretical paper hypothesizing that the stratospheric ozone layer might be depleted by chlorofluorocarbons, and before any empirical or observational evidence of actual CFC-driven depletion that didn't come till later, till the ozone hole was discovered in 1985, and the heterogeneous chemistry of chlorine ions depleting ozone molecules was observed only in the 1980s. And at that time, the European government hesitated and really took about 10 years before they caught up to American regulation. By contrast, for climate change, as you know well, the European Union has moved ahead more aggressively to regulate greenhouse gases than has the United States. The U.S. signed the Kyoto Protocol but did not ratify it. And the United States now has some policies at the member state level in California and the New England states, but does not have, and actually under the Obama administration has now been rolling out some new policies that are national in scope, but does not yet have the broad policies that we've seen in Europe over the last 15 years. Next slide, please. Hormones in beef and genetically modified foods, where the European Union and member states have adopted more stringent restrictions in anticipation of uncertain risk than has the United States. Next slide, please. Toxic chemicals, where the United States adopted new laws on pesticides and chemicals in the 1970s, but has not added substantially to those laws since then. And Europe has adopted the REACH policy since 2000, with more stringent requirements for testing of existing chemicals. And here's a couple of quotes on the reversal in chemicals policies from a newspaper article saying today the United States is no longer in the vanguard. Stockholm and Brussels are now the leaders on chemicals policy. And from two professors writing in a magazine that Europe is now the global standard setter for chemicals. Next slide, please. But there are some other examples that illustrate a more complicated pattern. So in our book, we have case study chapters on nuclear energy, where the United States, interestingly, took a highly precautionary stance after the 3 Mile Island accident in 1979. There were no new nuclear power plants licensed after 1979, a de facto moratorium. There are a few now in the application process, whereas in Europe, many countries continue to rely heavily on nuclear energy, much more heavily than the United States, and to have public opinion that was more favorable, that saw greater benefits to nuclear energy, and some countries adding new nuclear power plants during the more recent decades. Next slide, please. One of the most interesting cases we examined is mad cow disease, or bovine spongiform encephalopathy, BSE. Because there, almost all the cases of cows observed were in Europe, in the UK, or a few on the continent in the European Union. Hardly any cases in the United States. And yet, the United States adopted a ban on British beef several years earlier than the European Union did. And the European Union, after adopting its ban on British beef imports in 1996, then began undoing its ban in just a few years. Now, you might say that's just trade protectionism, and many precautionary policies are criticized as being disguised protectionism, and that may be. But what's particularly interesting is the last row on this chart, on this table, that says ban on UK-EU blood donors. Because the United States in 1999, but really before any cases had been observed of cows in the United States having mad cow disease, and certainly before any cases were observed of transmission of BSE to humans through blood donation,